Kobe 1 to Kobe 20A and B. Exhibit Kobe 21 and Kobe 22 were also tendered and admitted as evidence under cross-examination. Claimant was cross-examined by the defendant and closed his case as there was no re-examination. Defendant in his defense called Mr. Julius Oedeji, DW1, who adopted his witness statement on order dated 14 July 2020 and tendered exhibit KYS1 to KYS15A and B. DW1 was cross-examined and discharged as there was no re-examination, hence adjourning the matter for adoption of final written addresses. Claimant final written address. At the close of hearing and after the matter was adjourned to 21/1/2023 for adoption of final written addresses, and having the defendant not file his final written address, the claimant file his final written address The claimant filed his final written address on 5th of December 2023, wherein Learned Counsel on behalf of the claimant formulated 3 issues for determination. 2 which, number 1, whether the claimant having resigned from the defendant's employment on the 3rd of June 2015 via exhibit Kobe 3 can still be considered as an employee of the defendant and subjected to the defendant's disciplinary procedures and subsequent dismissal via exhibit KYS 12. Whether the defendant in purporting to investigate and discipline the claimant for gross misconduct and finding the claimant guilty of gross misconduct comply with the defendant's disciplinary procedure as contained in exhibit 18, which aims at affording employees the opportunity of fair hearing. Whether the claimant is entitled to damages for the loss of his employment with Unity Bank PLC and for his continuous inability to be gainfully employed in the financial sector until the defendant causes his name to be removed from the CBN Black Book. Let me just skip this. Just go to submitted, issue 1, issue 2. Then defendant's final written address. The defendant filed his final written address on the 21st of May 2025 and formulated 3 issues for determination to it. Whether the claimant's resignation during the pendency of an investigation into allegations of his misconduct was valid and effective to terminate the contract of employment between the claimant and the defendant. Whether the defendant accorded the claimant a fair hearing in the disciplinary committee proceedings. Whether the claimant is entitled to the anticipated wages claimed as special damages or to any damages at all. Defendant objects to paragraphs 18, 20, 22, 23, 23B, 28B, 28C, 28D, and 28E of the claimant's reply to statement of defense, and also object to the admissibility of exhibit Kobe 1, Kobe 14, 15, 16, 17, and argued that the above paragraphs are new facts which did not merely respond to the statement of defense but raised new issues demanding response from the defendant. Issue 1 of the defendant, yes, issue 1, let me just skip it. Issue 1, issue 2. Then claimant's reply on points of law. In response to the defendant objection against some paragraphs of the claimant's reply to assessment of defense, counsel contends that under the practice and procedure of courts, any party who, though did not plead a particular fact, will be allowed to adduce evidence on the fact pleaded by its adversary, where either giving evidence in support of the said fact or by either giving evidence in support of the said fact or evidence to challenge or rebut it. Council refer to Order 38 Rule 16.5 of the rules of this court. Council submitted the paragraphs of the defendant's final written address suggesting counsel giving evidence from chambers should be discountenanced and struck out by the court. But the law is tried, the address of counsel, no matter how brilliant, cannot take the place of evidence. Counsel rely on the Supreme Court case of UCHA and Eleti. The court will also urge to discountenance the defendant objection to the claimant's exhibit Kobe 14, 15, and 16, founded on the claimant's reply to similar defense. Counsel further submitted there is no law that requires an employee to compulsorily state in his resignation letter that his salary should be forfeited for failure to give notice, or that failure to state same, coupled with the failure to provide a check for payment in lieu of notice, will make such resignation letter invalid. Counsel continued that the issue of forfeiture of salary for failure to give notice is automatic, as it is an issue of law, are referred to the case of Mr. Frederick Obehon and Microfinance Bank Limited, delivered on the 11th of February 2019 by Honorable Justice Ade Wemimu. On the defendant's argument that the claimant secured employment from Unity Bank without obtaining a reference letter from the defendant, counsel contended that this is another case of counsel giving evidence from chambers in the final written address on a point that was never raised in any pleadings of the parties, and of which no evidence was proffered during trial. That the law is settled that counsel cannot, in the guise of a final written address, give evidence from the bar or in the final written address. Counsel rely on the case of Timothy and people of Lagos State. Counsel finally urged the court to grant the claimant's relief as sought. So my opinion, I have carefully gone through the pleadings filed by the parties and the evidence presented, having also taken into account the submission of learned counsel for the parties. The issue for determination I will address is whether or not the claimant is entitled to the relief sought in view of the fact and evidence before the court. The gist of the claimant, or the case of the claimant, is that he worked with the defendant from August 2013 to June 2015 and resigned voluntarily via a letter dated 23 June 2015. The defendant rejected the resignation, alleging that he was under suspension and investigation. But after the resignation, the bank set up a disciplinary committee which led to the dismissal of the claimant. That in March 2016, the claimant was blacklisted by Central Bank of Nigeria based on alleged fraud. He, however, secured a job with Unity Bank PLC in 2019, but he was later terminated when the Unity Bank discovered that he was blacklisted. It was contended by the claimant that his inclusion in the CBN Black Book was illegal and ultra-virus, and directly caused him loss of employment and reputation in the banking industry. It is a settled principle of law that where a party seeks the declaratory reliefs, as in the instance case, he must succeed on the strength of his own case and not on the weakness of the defense, if any. In essence, a declaratory relief must be proved to satisfy to the court to suspicion of the court, notwithstanding the default of the defense or any admission in the defendant's pleadings. The honor, therefore, is on the claimant to establish his case on the preponderance of evidence. See the case of Olayi Wola and Minister FCT, Glow and Fatmax Global Ventures Limited. Claimant, in trying to prove his case, has tendered, among others, exhibits Kobe 2 and Kobe 21, which are his letter of employment and the defendant policy manual, respectively. The said exhibit form a binding contract between the parties, and the core legal principle is that when two parties willingly sign a written agreement, they must abide by its terms. If a dispute arises, the court must resolve it based only on what is written in that agreement. The court cannot invent new terms or interpret things that are not clearly in the contract. This principle is supported by a court decision which states state that contracts are sacred and the regulatory terms are the ultimate guide for interpretation. A court's role is not to write a contract for the parties. See the case of Ahmed and CBN, Minaj Holder Limited and Amcon, Oyamanda and Abdurrahman. On the issue of the claimant's resignation, the defendant argued that the claimant's resignation, allegedly effective the same day the letter was presented, was ineffective and in breach of the claimant's terms of employment. That's why the defendant rejected the letter of resignation as the claimant was on suspension and under investigation for alleged forgery. Claimant resigned his appointment with immediate effect on 23 of June 2015 via Exhibit Kobi 13, which was received by the defendant on the same day. What then is the legal effect of this resignation with immediate effect? In Waek and Oshio Nebo, the decision supplied, it was held that a notice of resignation is effective not from the date of the letter or from the date of any purported acceptance, but from the date on which the letter was received by the employer or his agent. And the tender of a letter of resignation by an employee carries with it the right to leave the service automatically without any benefit, subject to the employee paying any of his indebtedness to his employer. In Mr. Bellot Patrick and Omatek Ventures Limited, the resume of which was delivered on 16th of March 2016, this court held thus, and I quote, resignation with immediate effect by an employee carries with it three legal effects: the right to leave service automatically, the employee's forfeiture of any benefit, and the employee paying any indebtedness to his employer. The justification for having to allow the resigning employee to leave immediately and automatically is the fact that he forfeits any benefit he may be entitled to, as well as the duty to pay of all indebtedness that he may have towards the employer. As such, the forfeiture of benefit inures as contractual consideration for the immediate and automatic separation of contractual relationship as per the employment in issue. So it cannot be that an employee who resigned with immediate effect is allowed to also benefit from such immediate separation by claiming benefits from the employer. In the instance case, the claimant resigned with immediate effect on 23 of June 2015, and the defendant received the same letter of resignation on the same day. When by the above case law authorities, the claimant's resignation was effective from 23 of June 2015, the date the defendant received the letter of resignation, and I so find and hold. This being the case, there was no employment relationship between the parties which the defendant can reject and so dismiss the claimant afterwards. By the case of Jumbo and PEFMB, it is elementary that an employee cannot be dismissed from an employment that had ceased to exist. Therefore, a dismissal coming after the termination of appointment would be a futile exercise. The claimant effectively resigned his employment on 3 of June 2015. There was no employment relationship on 3 of June 2015 for the defendant to suspend the claimant. Neither was there any employment relationship on 3 of June 2015 for the defendant to dismiss the claimant, and I so hold. In Ine Monday, in Betty and Unity Bank PLC, judgment of which was delivered on 21st February 2017, a clause in the employee handbook, as in the instance case which provided inter alia that the management reserved the right to reject a notice of resignation or payment in lieu of notice from an employee if it is seen as a strategy to cover up a fraud or misconduct to avoid disciplinary action, was not only struck down by this court, but it was held to approximate to forced labor contrary to Section 34 of 1C of National Constitution and Section 73 of the Labor Act. As such, the provision was held to be illegal and unconstitutional. In arriving at this decision, the court placed reliance on the ILO Convention concerning forced or compulsory labor, 1930, number 29, otherwise called the Forced Labor Convention. The point was stressed that there is absolute power to resign and no discretion to refuse to accept. And it's not even necessary for the person to whom the notice of resignation is addressed to reply that the resignation is accepted. See the case of Yusufu and Edo, governor of Edo State, Adefemi and Abegunde, Abayemi and Access Bank PLC, judgment of which was delivered on 23rd of February 2016. In Tadu, Gorono, and Goton, the court specifically held that no employer can prevent an employee from resigning from its employment to seek greener pastures elsewhere. It's not open to the employer for whatsoever reason to refuse to accept the resignation of the employee. For the employee has an absolute power to resign, and the employer has no discretion to refuse to accept the resignation. This being the case, the defendant's rejection of the claim's resignation is null and void and of no effect whatsoever, and are so fine and whole. The claim also contended that the defendant failed to follow the appropriate procedure of investigation and giving him fair hearing before filing a fraud indictment report against him with the Secretary of the Bankers Committee, Secretary of Bankers Committee for inclusion in the register of terminated, dismissed, or convicted staff of banks and other financial institutions. That his suspension and subsequent dismissal from the defendant's employment was wrongful. In Aminatu Omolalo Salami and Union Bank PLC, it was held that the position of the law is that when an employer decides to dismiss an employee on grounds of gross misconduct, the employer is duty bound to afford the affected employee fair hearing. It would appear to be true that a hearing need not attain the standard or form obtainable in the court before it can be said to be fair. Where a matter is not before the court, a court of law, what is generally required in order to afford fair hearing to a person is that there be an identifiable person or body or person empowered and capable of going into the issue in disputation, and that the person who is to be adversely affected by the decision, act, or proceedings be given adequate notice of what is proposed, and any allegation against him so that he will be afforded the opportunity to know the case against him to enable him prepare and answer the case against him. More so in the case of Skybank and Adegun, the court has laid down the requirement of fair hearing in the dismissal of an employee when it held thus, and I quote, despite the fact that an employer has the right to dismiss an employee, the dismissal should not be wrongful. The multiple questions which the court will consider in determining whether a dismissal is proper or wrongful will be, number A, was the dismissal carried out in line with the procedure laid down in the employer handbook or any document governing the employment relationship? B, was the issuer of the letter of dismissal competent to do so, or the dismissal process carried out by a competent authority? Was the employer afforded fair hearing during the dismissal process? The employer has the duty to ensure that it does not enigmatically raise its executive stick in operation of the employee, and it's important that every employer must be careful not to abdicate or abuse its power. It has been held that employers and public bodies are required by law at all times to act in good faith, reasonably and fairly towards people and matters under their charge in all circumstances. The law does not permit employers to act arbitrarily. The question of whether there was fair hearing during the dismissal process is so weighty that the court finds that an employee was not afforded fair hearing, it renders the dismissal wrongful, entitling the employee to damages. Having said that, the employer has the duty to ensure that the internal inquiry process or investigative panel hearing process, which is set up to hear and determine the allegations against an employee and based on which the employee was recommended for dismissal, was done within the dictates of the law. The dictates of the law as regards fair hearing is predicated on the 2 points. Simply put, they are that the employee must be given an opportunity to respond to the allegation against him and must have the opportunity to face his accusers as the case may be. Also, the person sitting in the investigative panel should not be the same persons as his accusers. Where these have not been observed, it cannot be said that the employee was afforded fair hearing before dismissal, therefore rendering dismissal wrongful. It should also be pointed out that an employee can be given an opportunity to present a case in defense of the allegation against him orally or right on court. Based on the foregoing authorities, it needs to be tested that why an employer dismissed or terminated the appointment of an employee on grounds of misconduct, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was afforded a fair hearing, that is to say the rules of natural justice were not breached and that the disciplinary panel follow the laid-down procedure, if any. The question now is, was the claimant given fair hearing, and were the laid-down procedures for an erring employee followed? In resolving this issue, the court needs to examine the defendant's disciplinary policy and sanction grid, which provides that for disciplinary measures to be taken when there is an allegation of gross misconduct, it is employed that before a sanction is applied, the culpable staff must have been queried and explanation obtained in writing. Furthermore, the employee should be given an opportunity to state his own case, either in writing or before the disciplinary committee during the course of investigation, and the appropriate disciplinary action to be taken must be consistent with the sanction grid. The defendant contended in the statement of defense that it invited the claimant to the disciplinary committee hearing of 2nd July 2015, with the letter dated 23 June 2015, through courier to the claimant's last known address, number 82 Ogule Street, Surulere, but the letter was returned undelivered, with the reason that the house address does not exist as the street numbering stopped at number 32. That it also sent 3 email notifications to the claimant's mail with a scarlet letter of invitation attached, notifying the claimant of the disciplinary committee hearing of 2nd July 2015. Claimant, however, denied receiving any mail through his email address, inviting him to appear before any disciplinary committee of the defendant. That the claimant never changed his house address at any time from the time he joined the defendant till date. The defendant branch, where the claimant worked as a branch manager, had an official vehicle, where the driver of the official vehicle oftentimes take the claimant in the said car to the claimant's house during official hours, to the knowledge of the defendant, and thus knows the defendant's house. The defendant also had the opportunity to deliver such correspondence through the said driver. I note that the defendant had attended exhibit KYS8 to KYS10, which are the email notifications of 23, 24, 6, 2015, 4, 9, 2015, and 5, 11, 2015, inviting the claimant to appear before the disciplinary committee. The defendant has not proved before this court that the emails sent to the claimant were either seen or read by the claimant. In fact, upon the cross-examination of DW1, he stated that there is no evidence that the claimant read his mail. I do not therefore see any reason to disbelieve the claimant that he neither saw nor read the emails. It is evident from the fact of this case as contained in the pleadings of the parties and their evidence. There's no evidence before this court to show or suggest that any query was given to the claimant about his involvement in the forgery of statements of account. There are also no evidence of the proceedings of any disciplinary panel where the claimant and any other person had any interface and interrogated each other about his alleged involvement in the forgery of the statement of account. I cannot agree with the purported justification of the defendant that it followed laid-down procedure in dismissing the claimant. I'm of the opinion that the dismissal of the claimant's employment on the grounds of involvement in the forgery of statement of account without giving him the opportunity to be heard was not justified, hence wrongful. After all, the claimant had already resigned when he was allegedly invited and when the disciplinary committee was purportedly constituted by the defendant. On the issue of failure of the defendant to follow appropriate procedure before filing a fraud indictment, report against the claimant with the secretary of the bankers committee for inclusion in the register of terminated, dismissed, or convicted staff and other financial institutions on the ground of fraud and dishonesty, paragraphs 4.0, 5.0, and 6.0, and 7.0 of the review of operational guidelines for blacklisting. The conditions and procedure for blacklisting have been spelled out. For ease of reference, the said paragraphs are reproduced below. 4.0, the blacklisted person is anyone who has been terminated or dismissed strictly as a result of fraud, act of dishonesty, and conviction. 5.0, a disciplinary committee must have conducted a thorough investigation. The disciplinary committee must have established that the staff involved had committed an act of fraud and dishonesty. The staff must have been granted a fair hearing to the disciplinary committee. The decision of the committee must be communicated to the staff involved. Upon verification of the existence of grounds for blacklisting, the financial institution shall notify the staff in writing informing him that A complaint for blacklisting has been filed against him, stating the grounds for such and consequences of being blacklisted. The staff must be given the opportunity to present documentary or verbal testimony that may affect the decision. C, the final decision of the disciplinary committee must be communicated to the staff. 7.0, the financial institution shall forward the returns owed on dismissed or terminated staff on grounds of fraud and forgery to the CBN, along with a declaration from the bank that it followed due process from before arriving at the decision, and signed by the managing director on court. Having earlier found that the claimant was not given fair hearing and that the defendant did not follow the laid down procedure in the disciplinary committee, I will not hesitate to hold that the steps taken by the defendant to blacklist the claimant's name in the register of terminated, dismissed, or convicted staff of banks and other financial institutions on the grounds of fraud and dishonesty is wrongful, having not met the condition and procedure for blacklisting a staff as set out in the review of operational guidelines for blacklisting. Having given due consideration of the facts and circumstances of this case, I wish to find on the claim for general damages that the act of blacklisting the claimant in the Central Bank of Nigeria's Black Book has occasioned a significant stigma and loss of reputation. I find that this injury to the claimant's character and standing is a proper foundation for an award of general damages. This is supported by the principle initiated in British Airways Limited and Makonjola on the claims for special damages, as it has earlier been established that a resignation with immediate effect by an employee entails certain legal consequences, notably the future of any attendant benefit. It's my finding that the claimant's immediate resignation was tendered in anticipation of imminent disciplinary proceedings. The claimant, having elected to preempt such proceedings, cannot now seek to claim the financial benefits he would have gained in his employment with Unity Bank PLC, has his employment not been terminated by the Unity Bank. To hold otherwise would permit him to eat his cake and have it, a principle not countenanced in law. Consequently, the claim for special damages is hereby refused and is accordingly dismissed. For all the reasons given above, claimant's case succeeds, with the exception of claim for special damages, which is rejected. For the avoidance of doubt and clarity, I make the following declaration and orders. Number one, a declaration that the claimant's employment with the defendant was duly terminated by voluntary resignation of the claimant via a letter of resignation of appointment dated on 3 June 2015. Number two, a declaration that the subsequent suspension and dismissal of the claimant from the defendant's employment after the claimant has resigned from the said employment is wrongful, invalid, and illegal. Number three, a declaration that indictment of the claimant for fraud by the defendant without affording the claimant the right to fair hearing amounts to a breach of the defendant's policies and procedures manual and the defendant's and the claimant's fundamental human rights to fair hearing. Number five, a declaration that the failure of the defendant to follow the appropriate procedure of investigation and granting of fair hearing to the claimant before filing a fraud indictment report against the claimant with the Secretary of the Bankers Committee for inclusion in the register of terminated, dismissed, or convicted staff of banks and other financial institutions on grounds of fraud and dishonesty, as envisaged under Section 48(4) of the BOFIA, make the said file fraud indictment report invalid, illegal, ultra various, null and void, and is hereby set aside. An order setting aside suspension of the claimant from the defendant's employment and subsequent dismissal from the said employment on the grounds that same was wrongful, invalid, and illegal. An order setting aside the defendant's disciplinary committee indictment and the claimant on the ground on the allegation of forged bank statement used in processing credit facilities as same was wrongful, invalid, illegal, ultra various, null and void. An order compelling the defendant to take immediate and appropriate steps towards the listing the claimant's name from the register of terminated, dismissed, or convicted staff of banks and other financial institutions on the grounds of fraud and dishonesty. A mandatory order directing the defendant to immediately delist the claimant's name from the register of terminated, dismissed, or convicted staff of banks and other financial institutions on the grounds of fraud and dishonesty. An order directing the defendant to notify the claimant in writing of the removal of the claimant's name from the register of terminated, dismissed, or convicted staff of the banks and other financial institutions on the grounds of fraud and dishonesty. An order directing the defendant to write a letter of apology to the claimant for wrongfully blacklisting the claimant's name in the CBN Black Book. An order of general damages against the defendant in favor of the claimant in the sum of 5 million naira for blacklisting the claimant in the CBN Black Book after the claimant had already resigned from the defendant employment. The judgment sum shall be paid by the claimant, by the defendant, within 30 days, failing which it shall attract 10% post-judgment interest per annum until it's fully liquidated. Judgment is entered accordingly.
My Lord, on behalf of the claimant, we are grateful that finally this case have come to an end. A case that started since 2019, 2020 has finally been laid to rest. We thank God for today, and we pray God to continue to grant your lordship the wisdom to dispense justice between parties fairly and justly. I'm most grateful to my Lord, and I ask God to bless my Lord.
Thank you. Kolawole.
My Lord, I'm indeed very grateful to the court for the efforts your lordship devoted to the judgments. From the reading of the judgment, it was apparent that my Lord devoted time in trying to do justice and seek a balance in the matter. We pray God to continue to grant wisdom to my Lord. I'm indeed very grateful, sir.
Yes, thank you, Kolawole. Thank you. Thank you.
My Lord, we will seek the leave of my Lord to excuse ourselves from the proceedings.
Mr. Kelly, you can go. You can leave. Thank you. Kolawole, do you want to leave?
My Lord, I can
leave?
leave, I can stay. Anything is all right by me.
Okay, it's okay.
Thank you, my Lord. I'm most obliged, sir.
Thank you.
My Lord, sir.
Yes.
Yes, my Lord. IS
Tayo, you are around.
Hello, my Lord.
Tayo, you are muted.
Hello, my Lord.
Can you hear me now, my Lord?
Yes, I can hear you.
Yes. I'm sorry, my Lord, that I'm late. I was late to join the Zoom.
It's okay. Good afternoon.
Good afternoon, my Lord.
Yes.
We have a matter, Aminat Oyas.
Aminat, yes.
Yes. My junior, I think he's already online. He was trying to talk to us now.
Imam Suleiman.
Imam, yes. Yes, my Lord.
Okay. Let me record the. So Tayo.
Kola Balogun, Mrs.
Kola.
My Lord, it's Taiwo, my Lord.
Taiwo, huh? T-A-I-W-O.
You keep mentioning Tayo, so I'm sorry.
Okay, not Tayo.
Yes, so it's Taiwo.
Taiwo.
Yes, my Lord.
T-A-I-W-O. Kola Balogun.
Okay. Balogun. With Imam?
Yes, I.S. Imam.
I.S. Ahmad, sir.
I mean, Ahmad.
Is it Ahmad?
Yes, my Lord. Ahmad. A-H-M-A-D, sir.
Like in Ahmad Tinubu?
Yes, my Lord.
Okay. For the claimant?
Yes, my Lord.
Okay. Okay, the judgment is here, but let me just quickly, run through because it's like my battery is going down.
I see.
So this suit was commenced by a general form of complaint dated 18th of December 2017 and filed on the 19th of December 2017, along with other accompanying processes. Rather from an amended statement of facts filed on 4th November 2022, the claimant is claiming against the defendants as follows. Number one, an order that the defendant pay to the claimant the sum of 179,000 naira, being 15 months arrears of salary and transport allowance. Number two, an order that the defendant
pay. I can't hear you, my Lord.
I say I can hear. I can hear.
Okay.
An order that the defendant pay the claimant the sum of 105,000 naira, being the service gratuity. Number three, an order that the defendant pay to the claimant the sum of 80,000 naira, being housing, medical, and leave allowance. Number four, an order that the defendant pay the sum of 45,000 naira to the claimant or open a retirement savings account and pay the money into it. Number 5, the general damage in the sum of 1 million naira for the financial hardship the claimant was made to encounter as a result of the action of the defendant. Number 6, cost of the action assessed as 500,000 naira, 500,000 naira only. The defendant reaction to the claimant's case filed the memorandum of appearance and joint statement of defense on 17th of October 2018. So let me just from the fact, this is the fact of the case of the claimant. I don't need to go through it. Defendant didn't enter his defense. His trial initially commenced on the 22nd day of November 2018 before Honorable Justice Mustafa Tijani. But upon his lordship transfer, the trial started de novo before me, while the claimant Mrs. Aminat Adoshoe on the 20th of October 2022 and 18th of January 2023 adopted a statement of witness statement on oath dated 19 December 2017 and a further witness statement on oath dated 4th November 2022. Claimant tendered her documents which are admitted and marked as exhibits C1 to C8. Claimant was cross-examined on the 18th of January 2023 by the defendant, and the matter was adjourned to 30th January 2023 for defense. On the 30th day of June 2023, despite the knowledge of the defendant that the matter was fixed for defense, the defendant counsel failed and refused to show up in court for their defense, and no causal reason was given for their absence. Thus, the court, upon the application of the claimant's counsel, brought pursuant to the provisions of Order 38, Rule 9 of the National Industrial Court rules, foreclosed the defendant, and the matter was adjourned for adoption of final written addresses. And following the failure of the defendant to file their final written address, the claimant on her part filed her final written address on 20th February 2023 and adopted same on 24th 7 2025. And other from the final address by the claimant, the other counsel for the claimant formulated 3 issues for determination 2. Just keep them. I will skip them.
As a call, please.
Just go to the
Judgment.
I've gone through the pleadings and the evidence adduced, having also studied the submission of learned counsel for the claimant. The issue I will address is whether the claimant is entitled to the relief sought. The brief fact of the case of germane to the issue to be resolved are that the claimant was offered employment by the defendant as a contract staff in 2007 and converted to a permanent staff on the 1st of November 2021 via Exhibit C1. That by Exhibit C6, the claimant's employment was terminated with effect from that 1st March 2017 on the account that the first defendant has not done any business, not generated any income since 2013, and has put only asset on the market in order to be able to meet all its financial obligations. The defendants still have failed and refused to pay the claimant her salary and other entitlements. I must state that notwithstanding the fact that the defendant did not call any witness, the burden of proof of the claim made by the claimant still rests heavily on the claimant owing to the settled principle that he who asserts must prove. See the case of Ayeni and Adeshina. From the above fact of the claimant, his net reliefs are for payment of some certain, which brings the reliefs within the realm of special damage. The point must be made that the onus of proof in this suit is on the claimant, who is to plead and lead credible evidence to support her claim before the court. In circumstances of this case, while the claims before the court are in the nature of special damages, the claim must be specifically pleaded with the particulars and strictly proved with verifiable and cogent evidence. The claim must not only plead damages sought, but she must also adduce credible evidence to support the claims in order to satisfy the court on how she arrived at the sum claim as special damage. The onus of proving her entitlements to monetary relief is on her to present before the court any document or instrument in proof of her entitlement to such claim. See the case of Mohammed Dungus and consortium. The claimant in this case ties her monetary claim to the termination letter Exhibit 6, issued by the defendant on the 3rd of March 2017, and the attached calculated entitlement computed by the defendant, which the claimant accepted. The defendant in clause 5 of Exhibit C6 undertook as follows, and I quote, "We hope that our plans to pay all our final entitlements materialize soon." Exhibit C6 was clearly calculated and computed by the defendant, and it goes without saying that same ought to be honored and fulfilled. In this regard, the court in the case of Williams and Williams held that the point, I will skip this quotation now. The indebtedness of the defendants to the claimant in this case is not in doubt. This was advised by the defendant in the statement of defense, who confirmed that the defendant are owing the claimant her entitlement. The law is long settled that fact admitted need no further proof. This also finds the free expression in section 123 of the Evidence Act 2011. See also the case of Feno and Bello. It is also not in doubt as admitted by the defendant that the claimant is being owed unpaid entitlement by the defendant. It's evident that the defendant were invited by the Office of the Public Defender. Claimant's solicitors equally demanded for unpaid entitlement, and all fell on deaf ears. The defendant had in the assessment of defense admitted the indebtedness to the claimant in terms of unpaid entitlement. However, the reason or excuse the defendant gave for the non-payment of the claimant's salaries and other entitlements is economic downturn. The defendant have not been able to prove the assertion on the non-payment of the claimant's entitlement. They have not also supported the assertion with any document or show that there's any genuine process that's ongoing toward the payment of the claimant's terminal benefit. It is clear to me that the defense of the claimant on why the salaries and entitlement of the claimant were not paid is a sham. It's a sham defense. In the modern day world of works, the position of the law is that whether termination or dismissal is wrongful or not, all earnings of an employee prior to the termination, dismissal, or resignation must be paid by the employer to such an employee. See the case of Odebunam and FCDA. Underwater Engineering Company Limited and DB Fund, where the Supreme Court held that an employer who desires to do away with the services of her employee must be ready to, with immediate effect, comply with extant provision regulating the relationship on payment of terminal benefits. The failure of the defendant to pay the entitlement of the claimant since March 2017, when the said employment was terminated, is unreasonable. The claim that there's a need for mediation is untenable, but there's no iota of evidence adduced before this court to show that there is mediation of any sort between the claimant and the defendant, or the need for such mediation. Bearing the foregoing in mind, it is clear that the defendant are under obligation to pay the claimant the entitlement of the claimant as computed by the defendant, I so fine and whole. The claimant also seeks for general damage of 1 million naira for the financial hardship she was made to encounter as a result of the actions of the defendant. The measure of general damages is awarded to assuage such a loss which flows necessarily from the defendant's act. It need not to be subsequently pleaded. It suffices if it is generally averred. It is presumed to be the direct probable consequence of that complaint of. See the case of Elf Petroleum and Omar. Unlike special damage, it is generally incapable of exact calculation. See the case of Federal Mortgage Finance Limited and Hope EPO. In the case of Ibrahim and Obaji, the Supreme Court held that, and I quote, "There's no yardstick for awarding general damage. In awarding general damage, the trial judge should examine the circumstances of the case and grant an award guided by what a reasonable man would expect." In the instance case, the claimant has given evidence on the refusal of the defendant to pay her salaries and other entitlements. As a result, the claimant had to go through the stress of mediation and litigation from 2017 just to recover her entitlement. I note the claimant's evidence that she had to contact the Office of the Public Defender, Lagos State Ministry of Justice, who consequently filed the matter in court just to recover entitlement duly acknowledged by the defendant in Exhibit C. I am therefore convinced that the claimant is entitled to general damage for what she went through. The defendant ought to pay the claimant some compensation for the stress she had to go through just to recover her salaries and other entitlement, and I so order. Having said that, I come to the conclusion that the sole issue formulated for the termination is resolved in favor of the claimant against the defendant. Wow. It's giving me
indication.
Yes. Yeah, the claimant is therefore entitled to the leave sought for, and for the avoidance of doubt, I hereby order as follows. Number one, an order that the defendant paid to the claimant the sum of 179,000 naira, being 15 months salary for arrears of salary and transport allowance. Number two, an order that the defendant pay the claimant the sum of 105,000 naira, being the service gratuity. Number three, an order that the defendant pay the claimant the sum of 8,000 naira, being housing, medical, and leave allowance. Number four, an order that the defendants pay the sum of 245,000 naira to the claimant as pension contribution. General damage in the sum of 500,000 naira for the financial hardship the claimant was made to encounter as a result of the actions of the defendant. The judgment sum shall be paid within 30 days, failing which it shall attract 10% interest per annum until the judgment sum is fully liquidated. 100,000 naira cost is awarded against the defendants in favor of the claimant.
We are most grateful to your lordship. The claimant will be very happy. Justice has been served. A 2018 matter that we came into. I am so happy, my lord, that we finally concluded it. Thank you, my lord.
Thank you so much, Taiwo. Not Tayo.
Not Tayo.
Not Tayo. It's okay. Thank you so much.
Thank you very much, my lord. I'm grateful. I am so grateful.
Thank you. You're welcome.
My lord, are you done for the day because of your battery?
Yes,
we're the last judgment.
Yes.
Oh, that's so good. Thank you so much.
We appreciate your lordship.
Thank you. Thank you so much. Aja. It's okay.
Bye-bye. Thank you,
bye
my
bye.
lord. Bye.
Thank you.
Bye.
Thank you. Bye-bye. I'll call you. Thank you. Okay.
Okay, sir.
Thank you, Aja.
Yes, sir.
Till we speak, inshallah.
Inshallah.
Okay.